Mike Brown, the former FEMA director.
Joining us here is the former FEMA director.
History, I think, was very unkind to you, my friend. Very unkind.
Mr. Brown, thanks for being with us.
This is Michael Brown Unplugged.
Welcome to this episode of Michael Brown Unplugged. Glad to have you with me. I want to talk about something that has been buried in the news because of all of the impeachment talk, and that is that the FISA court, the Foreign Intelligence Surveillance Court, which operates under the FISA Act, the Foreign Intelligence Surveillance Act. This is a law that was adopted back in, I think, 1978. That court, which operates in total secrecy, outside public view, outside public scrutiny, outside legislative scrutiny by Congress, it operates entirely independently, which may give you some idea about where I'm going with my attitude toward the FISA court. That court, based on the Inspector General Michael Horowitz, the Inspector General for the Department of Justice, based on his report about the FISA warrants, the FBI's use of uncorroborated evidence, based on the FBI's use of pure speculation, and the FBI use of newspaper reports to get a FISA warrant to surveil an American citizen, Carter Page. The FISA court and the inspector, let me back up. The Inspector General, Michael Horowitz, has found that there were inaccuracies, flaws, mistakes, and just outright malfeasance in the application and in the processes used by the FBI to get these warrants against an American citizen. The press, I would think, would be outraged by this. You would think that American citizens would be outraged by this, but we're not. And we're not because nobody's talking about it. Oh, there are editorials here or there. There was the other night on one of the nightly news shows, which I've gotten into a bad habit of watching. It just makes my blood boil. There was a short, in a typical segment of a news show, 22 minutes probably of actual news reporting. There was probably a 2-minute report on it, and it was very bland and didn't really have a lot to say about the significance of what the court has done. Now, those of you who have listened to me both on the podcast and on the radio program, you have heard me say on numerous occasions that I can't imagine, and that I certainly hope, that the FISA judges, most of whom we don't even know who they are, that these judges have, of course, they go home, they watch the news, they read the newspapers or the websites, and they understand what's been said. And I keep saying that at some point these judges have to. Let me put it in. Let me make two distinctions. The FISA court is not a criminal court. The FISA court, which is one of my constitutional objections to it, which I'll get to in a moment, the FISA court is actually an intelligence court. So they're taking these federal judges from around the country, and the Chief Justice assigns a certain number of them to be Foreign Intelligence Surveillance Court judges. They are operating in the intelligence world, not in the criminal world. So when people ask, well, why haven't these FISA court judges, hauled the FBI back in and said, I'm going to hold you in contempt unless you prove to me that you didn't do what the Inspector General said. I never expected in my wildest dreams that the court would actually come out publicly and say, whoa, hold on a minute. Well, the FISA court issued a rare public order this past Tuesday, in which it rebuked the Federal Bureau of Investigation for its handling of applications, as I said, to wiretap an American citizen, Carter Page. Judge Rosemary Collyer, the presiding judge of the FISC, the Foreign Intelligence Surveillance Court, called the FBI's actions, quote, antithetical to the heightened duty of candor owed to the court by government agencies. She wrote, referring to the behavior of FBI personnel that was criticized in the IG report, she wrote this, quote, the frequency with which representations made by FBI personnel turned out to be unsupported or contradicted by information in their possession and with which they withheld information detrimental to their case calls into question whether information contained in other FBI applications is reliable. So she did this, publicly did this. She ordered the Justice Department, no later than January 10, to explain what steps it was taking to prevent such lapses in the future, and indicated that she was planning to release more secret material about the Carter Page case in the coming weeks on the court's public docket, which would offer, I hope, additional insight into the government's most secret surveillance programs. This is so anti-American that it is just beyond belief to me. Now, when you think about what she did, she's given the she's given the FBI, the Department of Justice, approximately 3 weeks, January 10, to explain what steps have been taken to ensure the candor of every submission they have made. The language she used was each submission. Now, given that there are a hell of a lot of submissions, that might seem like an incredible burden in such a crunched time frame. Well, federal judges are known at times, particularly when they're upset about misconduct, and in this case, perhaps illegal conduct. They're known to put the hammer down and to say, I want the briefings, I want the facts, I want the responses pronto. And that's what she's done in this order. Now, the Foreign Intelligence Surveillance Court is actually just demanding to be satisfied that the FBI has done what it has led the court to believe it has been doing all along, and that is providing truthful, fact-based applications for warrants to the court. But setting all of that aside, I believe that there are constitutional problems with the Foreign Intelligence Surveillance Act. Back in 1978, when Congress created the court, I think it put the judiciary into what is a political function, i.e. intelligence collection. That's actually a political matter. That's not a criminal matter. That's not a civil matter in the sense of like a contract dispute. And it's certainly not a criminal matter in the sense that somebody's asking for a warrant to wiretap me because they believe that I'm engaged in some sort of organized crime, that I'm engaged in some sort of, human trafficking or drug dealing or money laundering. That's a criminal matter. And so when those kinds of things occur and law enforcement goes to a court to get a warrant, yes, that's done ex parte. That is done solely by law enforcement going to the court and asking for a warrant to put a wiretap on Michael Brown's devices. Now, why do I think that's constitutional, but what the Foreign Intelligence Surveillance Act does is not constitutional? Well, it's really simple in my opinion. The simple fact of the matter is, in a criminal matter where the FBI wants to wiretap me, there is a form of checks and balances. And that checks and balances is this. If the FBI wiretaps me and they make a determination that there is enough evidence, there's enough probable cause, I want to be very specific here, that there is enough probable cause to take me or take my activities either directly to an indictment or to a grand jury, a couple of things will happen. One, I'll get notification of that. I'll get notification at some point that I'm under criminal indictment, and now I can hire a defense lawyer, and we can challenge those warrants. We can actually go to court and make law enforcement, the U.S. Attorney's Office or local prosecutor, prove that they had a probable cause basis to get those warrants. And if they cannot substantiate that by sufficient evidence, we can make a motion to quash those warrants. And in some cases, if you quash the warrants, the indictment goes away because there's not enough evidence, there's no probable cause to proceed with the criminal case against me. So let's take it a step further. Let's say that they get the warrant against me to wiretap me. They don't necessarily use all of that information in what's called a preliminary hearing. That's where the courts, that's where law enforcement, the prosecutor, has to go into court and prove that there is sufficient evidence that I probably committed a crime, probable cause, and then the court makes the determination, yes or no. Is there sufficient evidence to believe that a crime has been committed and that Michael Brown has committed that crime? And if the answer to those two questions is yes, then in that preliminary hearing, I am then bound over for a full-blown trial. Now, I may not know much about the warrants in the preliminary hearing, but when discovery starts in the criminal case, I'm going to get access to all of the information, both against me and that is exculpatory, that is in my favor. And I'm going to be able then, through my counsel, to be able to challenge those warrants, to be able to challenge the very basis of the criminal charge against me. And to a certain degree, that's also true in civil cases. At least the discovery part is. You don't have a preliminary hearing, although you have a lot of preliminary motions in the civil case. You don't actually have a preliminary hearing. But you do have discovery. My point being that in civil and criminal courts, there is the opportunity to challenge the application for the warrants, and there is the opportunity to invoke all of the requirements of the Fourth Amendment, all of the requirements of the Fifth Amendment, to assure that indeed I get due process and that I am treated fairly and that I am still presumed innocent until the state proves beyond a reasonable doubt my guilt. And if they fail to prove beyond a reasonable doubt my guilt, I walk away free. So what's the difference between that and the Foreign Intelligence Surveillance Court? They're not looking at criminal matters. They are looking, or supposed to be looking, solely at intelligence and counterintelligence matters. Those are political issues. Those aren't criminal issues. Those aren't civil issues. That's a political issue. And the proper oversight for intelligence relies solely, no, I shouldn't say solely because the courts would have a role, but the primary role for oversight of intelligence matters is in the legislative branch. That's why, for example, you have a House Intelligence Committee. You have a Senate Intelligence Committee, so that they can have access to what the FBI or the CIA or any other intelligence organization is doing, so that they can exercise the oversight to see that those political issues are indeed being done properly. So back to my point about why I think that there are constitutional problems with the Foreign Intelligence Surveillance Act. What that act did in 1978 is it took the judicial branch and it threw it into what I believe is a political function of intelligence collection. And it's political in the sense that national security is a responsibility of the political branches of government. National security is not an issue for the courts. Oh, it may be at some point in some tangential matters, but intelligence collection is a function of the executive branch with oversight by the legislative branch. And I think if there are problems with intelligence collection, those problems can only be addressed legislatively. It is the Foreign Intelligence Surveillance Court's function to apply the Foreign Intelligence Surveillance Act. It is not to rethink it. It is not to consider, well, is this proper or not or improper? No, it's just to apply it. That's what the job of courts is anyway, to apply the law to the facts. Intelligence gathering is not always about facts. Intelligence gathering sometimes is about what we interpret that people are doing or even thinking. That does not belong in the judicial system. Think for a moment about counterintelligence. Counterintelligence, at least from my experience, is almost always classified to some degree because the goal is to collect information for national security purposes. It is not to build a criminal prosecution. And the vast majority of time in counterintelligence operations, there is no criminal indictment, and there's certainly no discovery. So there's no system like defense counsel to keep people honest. Now, if the Foreign Intelligence Surveillance Court cannot ensure that intelligence officials honor the codified standards of integrity and transparency, the system fails. And think about this. But for the Inspector General being asked by the Attorney General to look into these FISA warrants, we'd be at square one. There wouldn't be anything. There would be no oversight whatsoever. There's no defense counsel to stand up and say, because, for example, take Carter Page, for example. Now, he eventually learned that he was being surveilled, but most of the time you're not going to know that you're being surveilled, particularly in a counterintelligence matter. Now, in a criminal matter, you will eventually know that you have been surveilled because if that surveillance results in an indictment, criminal charges against you, then you're going to know that the evidence that they have against you was produced in part by wiretaps or other surveillance. And then you're going to have the opportunity to challenge that. Now, let's take Carter Page for a minute. Carter Page, but for suddenly all of this hullabaloo about Russia and the Mueller report and everything else, Carter Page would have never known he'd been surveilled. And even if he had known he had been surveilled by some magic fairy FISA court somewhere that let him know that he was being surveilled, what is his remedy? He has no legal remedy because this is an intelligence matter, not a criminal matter. Now, since this report came out, and since Judge Collyer made her anger known to the public, Judiciary Committee Chairman Lindsey Graham and others have said they want to pursue reforms. Now, some surveillance provisions are up for renewal in Congress this spring. That gives Congress an opportunity for legislative changes. And I've got one big legislative change that they ought to consider. Eliminate the FISA court. Eliminate the Foreign Intelligence Surveillance Act and start all over. Because all of the fears that I've always had about secret courts where there is no check and balance, where there is no opportunity for oversight by Congress. I mean, think about what Congress did when they did this back in 1978. They abdicated once again their responsibility for oversight. So if you want to reform and you somehow want to convince me that we still need a Foreign Intelligence Surveillance Court, then by damn have some legislative oversight. Give the Senate Intelligence Committee, give the Senate Judiciary Committee, and the parallel committees in the U.S. House oversight responsibility. Make it part of their job to make certain that somebody is looking at what they do. That's the very foundation of our government. Separate but equal branches of government, each in some way having a check and balance on the other. And in this case, there is None. Now, already, because of the likelihood of reforms or changes or congressional investigations and congressional looking into what's happened, the deep state and the bureaucrats, the permanent bureaucracy, are already beginning to scream that, be careful, be careful, be careful. Well, I'm not saying don't be careful in any reforms, but I think this is another fantastic example of how the administrative state that we have built up is out to do one thing: protect itself. If lawmakers do act, it will be important to not exert any undue collateral damage on the FISA statute, according to David Criss, the former head of the Justice Department's National Security Division. Criss, the founder of Culper Partners, a consulting firm in D.C., says, "You're doing surgery on a very complicated thing. That may sound trivial, but it's actually very important for national security." You know what? I understand national security. And I understand that we need to have intelligence and counterintelligence, that the CIA needs to be doing what it does to protect us from state actors and non-state actors who want to do us harm. I get all of that. But if we start going down the path that we're going to have these secret courts and, we got to be careful about the kinds of reforms that we do and everything else, you know what? Then I think, sidebar, let me just make here's a footnote. I had a Christmas dinner to go to a couple of nights ago. And excuse me, I've got a bug in my throat. So I had this Christmas dinner a couple of nights ago. And there were 3 retired cops there. One was a former state trooper. One was from a major metropolitan area, and another was a SWAT team and one-time sniper, good friend of mine. One of the retired cops and I know there are always these jurisdictional fights between the FBI and local law enforcement. I've seen that up close. I saw it on 9/11, hell's bells. I saw the internal battle between the NYPD and the NYFD. I mean, the police and fire departments battle all the time. So look, I understand turf battles. I fought turf battles within the Department of Homeland Security. But this one cop was adamant that it was time to disband the FBI. I don't know that I agree with that, but I listened to his arguments, and they were cogent, articulate, and well thought out. And he had a plan for what to do with the labs, what to do with training, what to do with everything, but that the FBI itself should be dissolved, and that the only thing the feds should be doing in terms of law enforcement is the labs and the training. I'm not sure I'm willing to go that far, but we have reached a tipping point in this country where there has to be systemic change in how we do both law enforcement and domestic intelligence gathering. There has to be, because we've now seen that the FBI, there's an old saying that you are known by your last worst act. And to some degree, I think that's true. I certainly believe in redemption. I certainly believe that people can overcome their last worst act. And in this case, maybe the FBI can do that. But right now, the FBI is known by their last worst act. And that last worst act is that they use falsified documents. They actually altered documents. They actually leaked things to the news so that they could use the news reports as part of their FISA applications. It was a circle jerk. Excuse my language, but that's exactly what it was. Congress, and I don't have a lot of faith in Congress. And if you've listened to me over the years, you know I don't have much faith in Congress. But I think here there should be enough members of the House and Senate that understand that the very foundational principles of due process, of separate but equal, of checks and balances, of all of the things that make this republic unique, they're on the line. Those things are actually on the line right now. So this, to bring it full circle, this rebuke, this public rebuke by Judge Collyer of the FBI and her demand that by January 10 they come back and they prove to the court that all of the applications that they've made have been lawful and factual and that they have not misled the court is gigantic news that's being lost in this dumbassery of impeachment, which, as a footnote to that, and by the time you listen to this, I don't know what Nancy Pelosi will do, but she's now actually, and some Democrats are floating the idea of not sending the articles of impeachment over to the Senate, but actually continuing their investigation of Donald Trump. We're in dangerous territory. Dangerous, dangerous territory. It is time for members of Congress to step up. And right now, I think the only place that can be done with any effect is in the United States Senate. Thanks for listening to me today. Be sure and drop me a line if you'd like to comment about the FISA Court or the Foreign Intelligence Surveillance Act. You can always find me on Twitter at Michael Brown USA or on Facebook, Michael D. Brown. And you can always follow the podcast, Michael Brown Unplugged. And if you haven't done so already, don't forget, subscribe to Michael Brown Unplugged. You can do that on iHeart, the Apple Podcasts, Google Podcasts. Well, frankly, you can just do it wherever you're listening to this right now. And if you've been enjoying the show, I'd appreciate it if you'd leave a 5-star rating or a review or leave a comment on any of the podcast platforms. Michael Brown Unplugged is written by me and it is produced by Right Turn Media. My marketing and social media is done by Whole Crowd. Thanks again for listening to Michael Brown Unplugged, and I'll talk to you next week.